Welcome to our deep dive on the lifetime bar for alien smuggling and how it differs from unlawful presence bars. In this video, we will clarify critical distinctions, outline waiver options like the I-601A and I-601, and walk through timelines, evidence, and strategy. This is a complex legal topic that affects many families seeking lawful permanent residency. Let's begin by setting the agenda. First, we will explain why this topic is crucial. Next, we will separate unlawful presence bars from the alien smuggling lifetime bar. Then we will compare waiver options, show process flows and timelines, and provide a preparation checklist. After that, we will add a special note for those who entered in the 1990s, test your knowledge, and finish with key takeaways. Before we proceed, please note that this video is for educational purposes only and is not legal advice. Immigration outcomes depend on specific facts, evolving policies, and agency discretion. You should consult an experienced immigration attorney who can evaluate your situation, determine applicable waivers, assess risks related to departure, and guide you through the process. Now, to frame the entire topic, imagine two separate obstacles: unlawful presence bars, typically 3 or 10 years, and the alien smuggling lifetime bar, which is far more severe. Each has different requirements and different waivers. Keeping them distinct will help you understand where you stand and which steps to take next. Moving on, unlawful presence bars arise from accrual of unlawful presence and trigger 3 or 10-year bars upon departure. Many applicants use the I-601A Provisional Waiver to address unlawful presence only. To qualify, you generally must show extreme hardship to a qualifying relative, usually a U.S. citizen or lawful permanent resident spouse or parent. Children are not qualifying relatives for I-601A hardship. If approved, you complete consular processing abroad. However, the I-601A does not waive alien smuggling, fraud, or other inadmissibility grounds, so this waiver is limited in scope. Next, the alien smuggling lifetime bar is codified at INA 212A6. It applies to individuals who knowingly brought, encouraged, aided, or assisted another non-citizen to enter the United States illegally. Critically, it applies even if the person assisted was a close family member such as a spouse, child, or infant, and even if the event occurred many years ago. The humanitarian motive does not negate the inadmissibility. This is a permanent bar, distinct from the unlawful presence bars. Relief may be possible via an I-601 waiver, subject to specific qualifying relationships, and a rigorous extreme hardship showing, typically completed through departure and a consular interview. Furthermore, consider the difference between I-601A and I-601. The I-601A is a provisional waiver designed specifically to address unlawful presence. It requires extreme hardship to a U.S. citizen or lawful permanent resident spouse or parent, and is filed while physically present in the United States before departing for consular processing. It does not cure alien smuggling. By contrast, the I-601 may be used to waive certain inadmissibility grounds, including alien smuggling in limited statutory contexts, and also requires extreme hardship to a qualifying relative. This path often necessitates departure for processing, is more fact-intensive, and is subject to strict scrutiny. Now, this flowchart shows a common decision path. If you entered without inspection, you typically trigger unlawful presence bars when you depart, which may be addressed by I-601A. Then, you check whether there was assistance to another person entering illegally. If not, you proceed to the consular interview. If yes, the alien smuggling lifetime bar applies, requiring the I-601 waiver. If you did not enter without inspection but there was alien smuggling, you still may need I-601. In some cases, both waivers are necessary. It is essential to identify qualifying relatives and hardship evidence early to avoid surprises later. Meanwhile, preparation is everything. Engage an experienced immigration attorney as early as possible. Map your full history, including entries, exits, prior filings, and any assistance you may have given to others entering the United States. Identify qualifying relatives and outline their medical, financial, educational, and community factors relevant to hardship. Gather comprehensive documentation, such as medical and mental health records, tax returns, employment letters, leases, school records, and community support letters. Provide a detailed, credible account of any smuggling incident, expressing remorse and context, without minimizing responsibility. Obtain records via FOIA or from agencies when helpful to corroborate facts, Build a strong, extreme hardship case with concrete evidence and, where appropriate, expert opinions. Discuss departure risks, consular processing steps, and backup plans with counsel. Ensure consistency across forms, affidavits, and evidence lists. Next, this table clarifies qualifying relatives. For the I-601A, qualifying relatives are typically a U.S. citizen or lawful permanent resident spouse or parent. Children are not qualifying relatives for I-601A purposes. For the I-601 in the context of alien smuggling, the qualifying relative category depends on the statutory provision and facts. Often a U.S. citizen or lawful permanent resident spouse or parent. It is essential to have an attorney confirm eligibility. In some cases, the same qualifying relative may be used for both waivers if they meet the requirements, but the evidence must specifically establish extreme hardship under the correct standard for each waiver. Additionally, individuals who entered in the early 1990s frequently face narrow options for residency today. Even if unlawful presence can be addressed through an I-601A, a prior smuggling incident often becomes the decisive barrier. These cases tend to involve longer processing times, stricter scrutiny, and the possibility of consular delays. It is crucial to consult an experienced attorney to evaluate the risks and determine a strategic approach before departing the United States. Quick knowledge check. Which waiver addresses unlawful presence bars, and which is commonly used when the alien smuggling lifetime bar applies? Option A. I-601A for unlawful presence. I-601 for alien smuggling. Option B. I-601 for unlawful presence. I-601A for alien smuggling. Option C. Both are the same. Option D. Neither applies. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is I-601A for unlawful presence and I-601 for alien smuggling where permitted by statute. The I-601A is a provisional waiver designed specifically to address unlawful presence, while the I-601 may be used to waive certain inadmissibility grounds, including alien smuggling, in qualifying circumstances. Second knowledge check. For the I-601A unlawful presence waiver, who counts as a qualifying relative for hardship? Option A. U.S. citizen or lawful permanent resident spouse or parent. Option B. U.S. citizen or lawful permanent resident child. Option C. Any U.S. citizen family member. Option D. No one. Hardship is not required. You may pause the video now to consider your answer. We will discuss the answer in the next section of the video. The correct answer is a U.S. citizen or lawful permanent resident spouse or parent. Children are not qualifying relatives for purposes of the I-601A hardship analysis, even though their situation can still contribute to the overall hardship picture. In summary, do not confuse the unlawful presence bars with the alien smuggling lifetime bar. The I-601A addresses unlawful presence, whereas the I-601 may address alien smuggling where permitted by statute. The alien smuggling bar can apply even for assistance provided to close family, and regardless of how long ago it occurred. Many applicants must depart the United States for consular processing, so planning for risks and timing is essential. Extreme hardship to a qualifying relative is the central requirement and demands strong, well-organized evidence. Above all, consult experienced immigration counsel. Now let me explain the timeline. The process usually begins with attorney consultation and detailed fact mapping. Evidence gathering follows, often taking 1 to 3 months or more. If unlawful presence is at issue, an I-601A filing may come first, with processing that can take many months. If the alien smuggling bar applies, an I-601 filing is required, which also has substantial processing times. After waivers, the case proceeds to National Visa Center case creation and document collection. Then comes the consular interview abroad. Some cases go into administrative processing, which can add weeks or months. Finally, if approved, the applicant receives a visa, returns to the United States, and is admitted as a permanent resident. Each phase has variable timing, depending on the facts and agency backlogs. To wrap up, Keep unlawful presence and the alien smuggling lifetime bar strictly separate in your analysis. Use the correct waiver for each, often the I-601A for unlawful presence and the I-601 for alien smuggling, and understand that some cases require both. Extreme hardship to a qualifying relative is the central element. Expect to depart for consular processing and plan for associated risks. Finally, work closely with experienced counsel to navigate evidence, timelines, and strategy. Thank you for watching. If you found this helpful, please like the video, share it with someone who might benefit, and subscribe for more immigration insights. Tell us your questions in the comments and let us know what we should cover next.